I call the regular meeting of the City Commission for Monday, February the 14th, 2001 to order. Commissioners, Commissioner Tillman?
Under number 6, the minutes of the Mount Pleasant Planning Commission. I note that there was discussion at that meeting regarding one of the items that was on their agenda for their approval. And in the course of the discussion, one of the planning commissioners had indicated talk about some fencing, and they were told that they couldn't address that because it had already gone to the Zoning Board of Appeals. This is not a process that I'm familiar with. I've talked with prior commissioners. They're not familiar with it. I'm really requesting that we review that process.
Thank you, Commissioner Tillman. Scott, do you have any comment on this?
Well, this particular item, what was before the Zoning Board of Appeals, there were 2 variance requests before the Zoning Board of Appeals. The fence was one of them, and I understand your concern about the fence. But the other issue was the use itself in that zoning district, and that variance was really required before the Planning Commission could act on it, because the Planning Commission couldn't act on the underlying use and site plan until the variance issue had been decided.
Thank you. Commissioner Joslin.
What about the fence?
Normally what's required for this type of use when it abuts a residential zoning district would be a brick or block wall.
And did the Planning Commission wish to, what did they want to do with the fence?
The Planning Commission asked about being able to impose that requirement, however, it had been waived by the Zoning Board of Appeals.
And they're going to the Planning Commission for a special use permit.
Yes, for the nightclub use required a special use permit.
Under a special use permit, can't the Planning Commission request additional items?
A special use permit is a discretionary review. You can't impose additional conditions within the criteria of the ordinance. That particular one had been waived at that point.
Vice Mayor had her hand up here, and then we'll go to Commissioner English.
I just wanted to ask, thank you, I just wanted to ask for, I think in part this has helped to illustrate why perhaps the original request that came from Commissioner Tillman would be worth pursuing at the meeting that we are supposed to have.
Commissioner English?
To follow up to Commissioner Joslin's question, so if I'm understanding this, the Planning Commission, even though they felt their hands were tied because this variance had already been granted, they could have gone ahead and requested additional recommendations to get the special use permit, and they didn't?
We've got a specific requirement in the zoning ordinance, and Zoning Board of Appeals said that that requirement is not going to apply to this particular piece of property. And so the Planning Commission really at that point lacked the ability to impose that same requirement that the Zoning Board of Appeals had previously granted a variance to.
Okay. Commissioner Tillman.
I just want to say I think this discussion underscores the fact that we need to follow up with some more discussion on this. What I'm questioning is the process, and I think we need to clean it up.
Yeah, and I think, again, as mentioned, we'll talk about this in our March meeting. That brings us to number 12. And before we take up number 12, I've asked our attorney to explain to us exactly what we are doing here and what is being considered and what are the parameters, and if you could summarize this for us, please, Scott.
The question before the city is twofold. First, does the proposed location comply with city ordinances and codes? And secondly, is there anything known about the applicant's background that would disqualify the applicant from holding a license under state law? As to the first issue, as we've noted in some of the previous discussion, all those land use issues and zoning issues under applicable city ordinances are really outside the purview of the City Commission at this point. The Zoning Board of Appeals and the Planning Commission has already acted on those, and there's no chance for the City Commission under our policies, procedures, and ordinances to now weigh in on that issue. As you also know, the relevant building code is the state construction code, and the appropriate city staff, the building officials, have acted on that, and they've found that the plans in that location will comply with the state construction code and the applicable fire code. The second issue concerning the applicant's background is a question that the Public Safety Department reviews. And in this situation, that department's found no reason that the applicant would fail to meet the legal requirements under the state's liquor control code.
Thank you very much. Any questions that the commissioners have of Scott here before we, or any clarifications? Vice Mayor Ling.
I'd like to just ask, we did have a suggestion that perhaps we redo the policy and then bring it back. And I know that from the neighborhood point of view, that might appear like something that we could do, but I know from communications we've received on this that would be difficult for us to do that. I wonder whether our attorney could address why we can't really at this point set it aside and redo the policy.
Well, the applicant at this point has applied under the current policy, and to change the policy after his application probably would be frowned upon by those who might review your action.
Commissioner Joslin.
The resolution of the letter we got from the state of Michigan simply says local legislation approval is required for new and transferring on-premise licenses. Well, where does it state in here that we have to have a policy on it, or if we don't have a policy that we have to do something specific?
The state says that local review is required, and they want the approval of the local legislative body. Applicants have been successful in challenging an ad hoc, case-by-case kind of determination without any specific criteria on a variety of legal theories. Now,
okay.
Any other questions for Scott before I call for a motion? Oh, you have a question or a motion?
Question.
Okay.
I have actually a few questions. Mr. Gray might be able to address most of them. When is the new facade scheduled to happen on the shopping center?
To my knowledge, there's no schedule on that at this point.
Okay. This is obviously a question that came up several times tonight. I assume we're checking who owns the fence?
We've pulled the site plan. It's on the property line.
So, but we don't know who's responsible for that fence yet?
The owner's just, I think each person's responsible for their side of the fence as far as we can tell at this point.
And the last question, which might be a bigger question, is east of Mission not set up to have bars?
The master plan doesn't designate specific uses. The master plan calls for commercial use along Mission Street on both the east and west sides of Mission.
Any other questions? Okay. I'm sorry.
While we have Mr. Gray up here, I actually did have a couple of other questions. Is it a nightclub that's going to be act as if they were a Class C restaurant 20 hours a day, but it's still a nightclub?
But I don't think that this fits neatly into the slots we've got in the ordinance. The way that we've tried to look at this is that for 4 hours of the day, this has the potential to be a nightclub. And so we took the position that if, even for just 4 hours of the day, it was going to be the more intense use, that it really ought to be regulated and reviewed under that.
Commissioner Joslin.
Since you're up here.
Sure.
Commissioner Tillman and I have been arguing about this for a few minutes now. The applicant and everybody keeps talking about these 100 seats. And we've counted 3 times now and we keep coming up with 79. Where's the other 20 seats?
There are 2 layouts that the applicant has prepared for that the Planning Commission reviewed. I'm not sure what you have.
So when the dance floor is there, there's not 100 seats.
That's correct.
But when the dance floor is gone, there's the 100 seats.
Yeah. That's correct.
Okay. And did we ever get an answer from the question from the Planning Commission, wondering if it had to always be 100 seats or if it just needs to be 100 seats for X amount of hours of the day?
We have not gotten an answer. That is a state licensing requirement, and what the Planning Commission did was approved the special use permit based on the layouts provided by the applicant. In the event that the state requires more seats, the applicant will be required to come back to the Planning Commission with a new layout to show those seats. What we have,
state agency approves or requires that? That's the LCC?
Yeah, that is a requirement. It's my understanding that the resort license requires the 100 seats.
Commissioner McGuire.
I'd like to move item number 12.
Thank you, sir. Item number 12 has been moved by Commissioner McGuire. Is there a second? Commissioner Joslin. Any discussion? Mr. Joslin?
I'll be honest with you, I truly have mixed emotions on this proposal. I think it's funny that if the applicant was an Olive Garden, this conversation would not be taking place whatsoever. So, I don't know. I'm anxious to hear some of the other commissioners' comments. I think it has potential, but I'm not completely sold on it yet. So I wouldn't mind hearing some of the other commissioners' thoughts.
Commissioner Tillman.
Well, I have some mixed feelings, too. My issue was the process that appeared that if someone on the Planning Commission had an issue with the fence, evidently they felt that their hands were tied. That was my point, not the fence. I like to support good economic development. I also like to have our neighborhoods protected. So I guess we get back to the fence. I hope someone does something about that.
Thank you. Vice Mayor Ling.
A couple of things. The first is that the answer that we got from the Director of Planning on the why they were given the permit as a nightclub made a lot of sense, but it also was one of the reasons why I have a concern. Whenever the issue of not having the 8-foot fence comes up, the response is, well, we're basically going to be a Class 1 restaurant. And that's the reason why we don't need to have the 8-foot fence. However, the reason why what I'm hearing is the reason why the staff wanted to have it classified as a nightclub is because of the adverse impact when they are operating as a nightclub. The noise and the lights and everybody leaving at the same time. And that's why the code says if you're a nightclub, you need to have an 8-foot fence. So if you're going to be operating as a nightclub during the time when the adverse effects are going to happen, then I have a problem with saying, but we're going to declare you a nightclub, but we're not going to have you put in one of the primary ways in which we try to deal with that adverse effect. But as our attorney indicated to us, that's not an issue that we get to decide on tonight. I think that we need to address the issue of the variances and the change that's occurred. And I know that the process, I don't know what the process should be. I know it's different now than it was a few years ago. And there was discussion of trying to speed up the process a little bit and make it a little more business friendly. And I think the question becomes in doing that, did we end up with a situation where the Planning Commission perhaps felt they couldn't do some things they normally would have done? So I do think that issue needs to be addressed. I think more importantly, we need to address the issue of the on-premise liquor license. And I'd like to make sure that our online liquor policy allows us to have criteria to decide when we, in fact, want to have a license transferred into our community so that we're not stuck with a situation where we have to approve it because we don't have any criteria to decide on. And the last thing is, and we haven't talked about this at all, but this was talked about at the Planning Commission meeting, is the enforcement. We have in our zoning ordinance a section that says if you get a special use permit to serve alcohol, you must turn into the city manager's office at the end of each year records indicating that you are, in fact, having more than 50% of your food, 50% of your sales in food. And apparently we've never operationalized that. And I'd like to request that as part of this discussion that we look at how we can operationalize that, because I think it's very important that we have local enforcement of that.
Thank you. Any other discussion? Commissioner English.
Want to make sure the gentleman knows that we take our neighborhoods very seriously. I also want to hold you accountable to your word that this will be a positive development in our community, and again, encourage neighbors and anyone who sees that this might not be a positive to make that phone call to the state. Hold them accountable. While we might not be able to do things from a policy perspective, we can do things as a community. So I wish you well.
Any other discussion? Okay, I would like to say that, as the Vice Mayor has pointed out, we've learned a lot from this. I think we can make some improvements, as Commissioner Tillman suggested at the beginning and the Vice Mayor suggested, and we can look at procedures and enforcement and new criteria. What we're looking at here tonight, it's been approved by the Planning Commission, by the ZBA, and whether or not the ordinances have been complied with, which they have, and the background of the applicant. So I'll be supporting this motion also. Any other discussion before I call for vote? All those in favor say aye. Aye. Opposed?
No.
Okay, the motion carries.